Hi, good morning, everyone. This is Rajeshkumar. Today, we are going to analyze one problem question on mistaken equity, and we are going to discuss the doctrine of mistaken equity as well. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer. Let's move on to the problem question. The former doctrine of mistaken equity was regrettably brought to an end by the decision of the Court of Appeal in Great Fish Shipping versus Salvage case in 2002. The related problem question is the Hall. He meets Imogen at a business meeting and agrees to buy her car from her for £25,000. We have to advise Imogen in the following two scenarios. Whereas the both Hall and Imogen believes that Imogen's car has a 12-cylinder engine when it only has a less powerful 6-cylinder engine. The second case, Imogen travels to work by train. On the day she meets Hall, her garage at home burns down shortly after she leaves the house and her car is destroyed. Imogen only learns of this when she returns home that evening. The Great Peace Shipping Limited versus Salvage in 2002 case significantly altered the landscape of English contract law regarding the mistakes by abolishing the equal doctrine of mistake, effectively narrowing the scope of relief available for contracts based on mutual mistake. In Great Peace, the both parties mistakenly believed that the ship, the Great Peace, was in the proximity to another vessel in distress. The Court of Appeal ruled that the contract was not void for mistake, emphasizing that equitable relief should not extend to contracts that remain performable under their terms, even if based on a shared erroneous assumption, concluded that the mistake must make a performance impossible or alter the contract's essential nature, aligning more closely with a strict common law test established in Bell versus Lever Browse Limited. Previously, Soleil versus Butcher allowed the equitable relief, making the contracts voidable when a fundamental mistake was present, even if it did not render the contract impossible, but merely different from what the parties anticipated. The Great Peace decision dismissed this dual system, arguing that it caused confusion and lacked a clear test to separate the common law and equitable remedies. Although it's reduced the flexibility, it promoted certainty in contract enforcement, upholding the agreement despite mutual mistakes, provided that performance remains possible. In other words, the doctrine of a mistaken equity was historically applied in English law to grant a relief in cases where a mistake made a contract fundamentally unjust, even if the mistake did not void the contract at common law. However, the Court of Appeal in Great Fish Shipping versus the Salvage International Limited case in 2002, it abolished the doctrine, aligning the equitable relief with the more restrictive common law principles on mistakes. Prior to the Great Peace, the doctrine of mistaken equity allowed the contract to be set aside or rescinded where both parties were mistaken about a fundamental fact, provided that it would be unjust to hold the parties to their agreement. The equitable approach was less rigid than the common law mistake, which traditionally required the mistake to render the performance of the contract impossible. In Soleil versus Butcher case in 1950, the Court of Appeal, led by Denning L.J., established that equity could intervene to set aside a contract for common mistake, even if the contract remained valid at common law. This allowed for greater flexibility in dealing with unfair contracts. In Grist versus Bailey case in 1967, the equitable doctrine was further applied to grant relief for mistakes that, while not meeting the strict common law standard, still rendered the contract fundamentally unjust. In a great peace shipping, the Court of Appeal abolished the doctrine, equitable doctrine of mistake, holding that the only grounds for setting aside a contract due to mistake were those established in common law as set out in Bell versus Livers Bros Limited in 1932. The court ruled that there was no separate doctrine of mistake in equity and that the test for mistake should be unified under the common law principles. In this case, the mistake related to the location of the salvage ship, but the court held that it was not sufficiently fundamental to void the contract under the common law principles. The abolishment of this equitable doctrine of mistake is arguably regrettable because it removes the flexibility that equity provided in dealing with unjust contracts. By aligning the mistakes with the strict common law test, which only allows for the relief when a mistake renders the contract impossible to perform. The decision in Great Peace Limited, the court's ability to address the unfair contracts. The common law approach requires the mistake to be so fundamental that the contract is impossible to perform. As in Bell versus Lever Bros case, where the mistake did not affect the core bargain, the rigid approach often fails to address situations where a contract is still technically possible but inequitable, which equity could have remedied. In modern commerce, where the contracts are often complex and subject to unforeseen development, the need for equitable intervention is even more pronounced. The decision in Great Peace effectively prevents the relief in cases where fairness demands its batch, where the mistake does not meet the strict common law criteria. To conclude, the Great Peace Decision is widely viewed as a regrettable development because it removed an important mechanism for ensuring the fairness in contract law. The equitable doctrine allowed for a more nuanced approach that addressed the unjust contracts, while the unification of the doctrine of mistakes under the common law may provide clarity, it sacrifices flexibility, leaving some parties bound by contracts that are fundamentally unfair. Let's move on to the problem question. The mistake regarding the core specification. First, we'll look into the mistake regarding the car specification. In this scenario, the both Hall and Imogen mistakenly believed that the car had a 12-cylinder engine. This is a common mistake about the quality of car. Under the principle from Bell versus Lower Bros in 1932 case, a mistake regarding the quality typically does not void a contract unless the quality in question makes the item fundamentally different. Here, the car is still a vehicle and operable, so the mistake about the engine's power may not satisfy the threshold to render the contract void. Similarly, in Associated Japanese Bank versus Credit New Note case also reinforces that the mistake must make the subject essentially different from what the parties believed for the contract to be void. In other words, based on Bell versus Lever Bros case, the mistake about the car engine may not be fundamental enough to void the contract. The car still exists and the function albeit with a less powerful engine. As in Bell, the mistake does not render the contract essentially different from what was agreed. And similarly, in Nicholson versus and Venn versus Smith Marriott case in 1947, this case dealt with the sale of an linen where both parties were mistaken about its age. The court held that the mistake was not fundamental enough to void the contract. As the linen was still usable, the reasoning could be applied here. The car still functions even though the mistake about the engine could affect its value. To conclude, the mistake about the engine, while the material may not be fundamentally enough to void the contract under the strict test established in Bell versus Lever Bros, Imogen would likely still be able to enforce the contract unless Hall could prove that the mistake made the car fundamentally different from what was bargained for. It is likely valid since the car specification does not fundamentally alter its existence or use. So, although Hall may have grounds for rescission based on misrepresentation if Imogen confirmed the engine type. Let's move on to the scenario 2, wherein the Imogen car is destroyed in a fire after the agreement. In this scenario, the car is destroyed before the contract is completed, raising issues of frustration and non-existence of the subject matter. In Courtier versus Hasty case in 1856, the court held that a contract for a sale of the goods that no longer exists at the time of the contract is void because there is no subject matter. Here, the car is destroyed before Imogen can transfer it to Hall, meaning the contract could be void due to the non existence of the car. Under Section 6 of the Sales of the Goods Act 1979, this section codifies the principle from Kocher versus Hesse case stating that if the subject matter of a contract has perished without the seller's knowledge at the time of the contract is void. Since Imogen was unaware that her car has been destroyed when she agreed to sell it, under Section 6 would apply and the contract would be void. Similarly, this is McRae versus Commonwealth Disposal Commission case in 1951. The court refused to apply the principle in Courtier because the seller had guaranteed the existence of the subject matter. However, in Imogen's case, the car existed at the time of the agreement and it was destroyed after the agreement, distinguishing the case from McRae. The situation presents a mistake as to the existence of the subject matter, invoking res extincta, according to Cote versus Hasty, and reinforces by the Section 6 of the Sales of the Goods Act 1979. A contract for a specific item is void if the item perishes without the seller's knowledge before the contract completion. So, in this case, the emotion could be the contract is void as the car ceased to exist due to unforeseen fire. The contract would be void under the res extincta as the car no longer existed at the time of the agreement, making the performance impossible. Hence, the contract agreement between Imogen and the Herald is likely void under Section 6 of the Sales of Goods Act 1979, as the car was destroyed without Imogen's knowledge. This case is more akin to Courtier than Macrae, as Imogen did not guarantee the car's continued existence. Let's conclude. The decision in the Peace Shipping to abolish the equitable doctrine of mistake has been criticized for removing the flexibility from the court's ability to address fundamentally the unjust contracts. By unifying the mistakes under the strict common law test, it limits the ability to provide equitable relief in cases where a mistake does not render performance impossible, but still it makes the contract unfair. In the case of Hall and Emergent Scenario 1, likely does not void the contract as the mistake about the engine, while the material does not make the car fundamentally different. In Scenario 2, however, the contract is likely void under the Section 6 of the Sales of the Goods Act 1979 as the car was destroyed without the emergent's knowledge, meaning the subject matter no longer exists. Thank you.